Thank you very much, Registrar. Maybe moving forward, what you should do is probably guide now political parties on how to do those programs and make proposals of what legislative interventions would be done for those party programs to be there. So that as I run for a seat on UDA, this is what I subscribe to.
Sure.
Okay. Thank you. We have heard you, all of us.
Thank you. Thank you very much.
So next we have Attorney General Emeritus, Professor Githu Muigai.
Thank you.
Who is also an old boy of the school. Used to beat us in rugby.
Thank you very much, Chairman and members. Thank you for inviting me. I have very few words because you have directed me to the specific issues that you would like me to pronounce myself on. And subject to any further directions, I want to go straight to that agenda.
Please do.
The first question that you put to me relates to the question of restructuring IEBC and the audit of the 2022 elections. First, I would like to state that it's been my very unfortunate duty to be involved in the reconstitution of IEBC previously, a process that was very, very difficult for all the parties involved. I remember that we disbanded the entire IEBC, sent them home, and we started afresh. I would personally be against institutionalizing that kind of thing. I do not support creating a permanent state of instability in institutions. For example, we have reconstituted the judiciary twice. And I think that some good gains were made by that process, but I think that that process created some inherent instability in the institution itself. But I'm not here to talk about the judiciary. I'm here to talk about IEBC. We have tried several methods of constituting IEBC. When, Mr. Chairman, you recall, we came out of the crisis of the 80s, and we had IPPG. It was thought that what we should do is to allow political parties to nominate individual members into the IEBC. It was an unmitigated disaster. It was an unmitigated disaster. And I don't think we should be tempted again to allow party participation in the appointment of commissioners. I believe myself that we need an independent, robust process of recruitment. At the present, I am not very sure that the system in place is giving us our best first 11. Now, how can we strengthen it? I think that, for example, when they say the Law Society of Kenya, my own professional body, is to send a representative, I am not very sure that that necessarily creates autonomy or when they say religious leaders will have representatives, or trade union leaders, and so on and so forth. I think we need to find a way of forming that constitutive body that will interview those who qualify for these positions. I agree with those who say that there is no legal reason why the chairman should be a lawyer, because the election is more than a legal process. It's a management process, and what we want to do is be able to elect into the commission good managers, strong managers, proven managers, who then can hire the best lawyers that they can, either within the secretariat itself or from outside the secretariat, hopefully whom they can be able to pay. Number two, should we go back to ask ourselves what happened in the 2022 election? My own honest opinion is that it is not a useful exercise. Why is it not useful? Because again, it reopens the question that has been resolved with finality by the Supreme Court. The challenge with reopening matters that have been judicially settled is that you, by necessary implication and inadvertently, you create the possibility that confidence in that institution can be eroded. And I don't think that that would give us, in going forward, it would create a permanent state of electoral instability, because no matter who would win or lose, no matter what the Supreme Court would say, that party would say, we know. In fact, in that year, the Supreme Court said this, but when we did a forensic audit, the forensic audit produced a different outcome. Remember, ladies and gentlemen, that the work of the Supreme Court, is not to declare that the election was conducted without a hitch. That is not the standard. It is not to find whether there was any hitch. In fact, since I started participating in these elections in 2013, before the Supreme Court, 10 years ago, the Supreme Court has always said there was a hitch. There was a hitch. But the standard of the law is, was there a hitch of such a substantial nature that it affected the outcome of the election? And in 4 of the cases I participated in, the answer was no. In one, the Supreme Court said, yes, this is not good. This is not a hitch. This has gone beyond a hitch. I didn't agree with them then, but I respected that opinion and I obeyed it. And as the Attorney of the Republic, I went back and started arranging for a new election, which we did hold thereafter. One of the problems we have, ladies and gentlemen, in these constitutional timelines that are locked up in the Constitution, it confirms what the philosopher said, that the road to hell is paved with good intentions. When we wrote the Constitution here in Bomas, we thought that putting timelines by which the court must determine the dispute, we were making sure that the country would be stable, that a transition would be done quickly. We were wrong. It now turns out, in my experience, that this time is not enough. And this method that we use, this method that is by documents only, by affidavits only, and so on, is not enough. So that's one thing that if we were to reopen that process, that is one area that the experts would probably need to look at, the timelines. In fact, we almost ran into a constitutional crisis in 2017. We dodged a bullet by the sheer love of God, because Parliament had broken up, had prorogued, Parliament had gone home, it couldn't make more law, it couldn't make law to guide us, and the judges had found the night before the election that election officers had been wrongly appointed. It took the Court of Appeal sitting at night to deal with that technical problem. Where the life of the nation is concerned, we don't want those near hits. We then went into an election where I think had we missed the timeline, there would have been no government, and that's the constitution we have. If the election is not, for example, if we do an election, the Electoral Commission declares a presidential winner, a petition is filed, members of the Supreme Court are kidnapped, we do not hear the petition and finalize it within the period provided, then we have no government. I think these are very dangerous propositions, and we want to have a more flexible system. And I know there are many experts who can help us deal with that. So that's all I wish to say about IEBC, about reopening the question. About boundaries delimitation, I want to start by saying that my own personal view, which is not a view shared by many of my countrymen, is that we have too many people in Parliament. We have too many constituencies, so that we should be reducing constituencies, not increasing. We have too many counties. We should reduce counties, not increase counties. They are costing us a lot of money, and quite a number of them are not viable. When we were in Bomas, the constitution we gave you, ladies and gentlemen of the Honorable August House of Parliament, I think we had given you 9 counties. 14, I'm corrected, 14. It was when the politicians went to Naivasha that they came to this compromise of let's go to 41. I think if we are to reopen this constitution, one of the issues we can usefully reopen is the reduction of counties. Bring more counties together and let them work together and mobilize resources together and share together. So I'm not a great fan of increasing counties or indeed of increasing constituencies. And this may bring me then to another issue which I was supposed to take later. This issue of the gender rule, we call it the gender rule, but essentially, really, it is the women empowerment rule. I struggle